Lionel Dahmer, the father of the infamous serial killer Jeffrey Dahmer, says that he might sue Netflix, but I don't think that it's likely to go well for him. Let's talk about why. Hi everyone, welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel we make sense of the law one bite at a time. So this was initially reported by The Sun, and I know there is a tail in the way. Anyway, and I know that there are a lot of opinions about The Sun coming out, particularly coming out of the Johnny Depp versus Amber Heard trial. But nonetheless, let's see what they have to say. So according to The Sun, Jeffrey Dahmer's dad is seeking legal advice on whether to sue Netflix over 2 new shows about his serial killer son, a source has told the U.S. Sun. And that's because according to Lionel Dahmer's caretaker, Lionel was upset that he was never contacted regarding Netflix's series Dahmer Monster, the Jeffrey Dahmer Story. And separately, he says Lionel is also seeking legal advice about his unhappiness over Netflix using tapes made by Dahmer's legal team for the new docuseries Conversations with a Killer, the Jeffrey Dahmer Tapes. Specifically, Lionel claims Netflix never sought Lionel's permission to use those tapes. Now first, who is Jeffrey Dahmer? There is a high likelihood that you already know that, but just in case, to make sure that we're all on the same page here, he's an infamous serial killer who reportedly confessed to the rape, murder, and dismemberment of 17 men and boys between 1978 and 1991, and who was convicted of 15 of those killings. I'll spare you the gory details, but if you want a hint on some more that lurks in there, he was also nicknamed the Milwaukee Cannibal. Now, the 2 Netflix programs at issue here are about Jeffrey Dahmer, his heinous acts, and how they spilled out onto the people around him. So, does Lionel Dahmer have any legal claims that he can successfully sue Netflix over for each of these programs? To be honest with you, I really don't think so. Let me tell you why, looking at each of these Netflix programs. So the first one is the dramatic retelling of the Jeffrey Dahmer story, starring actor Evan Peters, and it doesn't present much of a case here for Lionel Dahmer. His main claim here is that Netflix never contacted him ahead of their production of this dramatic series. But the only thing that I can think of here in relation to this particular complaint is maybe something having to do with a claim for the right of publicity. An actor does appear in the show as a character depicting him, and it's very clear who he is and the role that he's portrayed as having in Jeffrey's life. And that can be a potential tripwire for someone's right of publicity. We typically think of the right of publicity as just for celebrities, but it's a right that we all actually have, which is the right to give or to refuse authorization of your name or likeness, typically in a commercial setting. Over the years, there have been some celebrity lawsuits about the right of publicity, cases like White v. Samsung, where Vanna White won against Samsung when they tried to use a robot version of her standing in front of a Wheel of Fortune game board in an advertisement to sell VCRs. And I can't believe I feel like I need to explain this, but VCRs are the predecessor to DVDs, which are the predecessors to streaming services. Am I old? Am I getting old? Anyway, there have been other celebrity lawsuits as well, filed by people like Bette Midler, Johnny Carson, Kareem Abdul-Jabbar, the list goes on. But there's an important limitation on the right of publicity. And every time we're talking about messaging, expression, some potential artistic expression, we're getting into First Amendment territory. If the right of publicity claim comes out of a work that is artistically expressive and not just strictly commercial, that right of publicity really starts to diminish in the face of the opposing First Amendment right. And that diminishes further where it's also potentially newsworthy. Although Dahmer hasn't been in the news for a long time, just weeks after he was convicted, he was reportedly killed by another inmate. The public has been fascinated by his story ever since news first broke about his long-term killing spree. And we're talking about a dramatic retelling of those events, which is going to have some creative license employed as well. Now, don't get me wrong, many have criticized the Netflix series, and in my opinion, rightly so. Factual inaccuracies about victims reopen old wounds for family members, as do gruesomely reenacted depictions of their deaths. A lot of people also are very uncomfortable with the way the series seems to glorify someone who did some of the most heinous acts any human being can even really think of. And these are just some of the things that this series is being criticized for. But as far as any right of publicity claim is concerned, it's likely to be trumped by the fact that, like it or not, this is an expressive work, and so Netflix's First Amendment rights are likely to win out. Okay, so that's the first Netflix program. What about the second, the one featuring the Jeffrey Dahmer tapes? Well, in order for Lionel Dahmer to sue successfully on that one, he'd have to have some kind of ownership or some other legal right to those tapes. And as far as I'm aware, those tapes were recordings of Jeffrey Dahmer telling his lawyer, Wendy Petricus, all of the gruesome details of his crimes. They were recorded when he was in prison and for the purpose of preparing his legal defense. For one thing, nothing I've been able to gather about those tapes suggests that Lionel Dahmer's voice is in any of those recordings. So there shouldn't be any right of publicity issue here. Second, I'm not certain that he would even have any kind of an ownership claim over those. They would either likely be owned by the firm or by Jeffrey Dahmer, which I guess could, in sort of an intestate kind of probate way, pass ownership to Lionel Dahmer himself. But even still, that's not entirely clear. But there is another issue here that you might be able to pick up fairly quickly, which is that this is a series of confidential conversations between a lawyer and her client. So it's natural to ask, what about the attorney-client privilege? As you probably know, the attorney-client privilege is what keeps private certain communications between the attorney and the client. Those communications span basically anything and everything communicated between a client and their attorney or the attorney's staff for the purposes of representation for a particular legal issue. To be succinct, anything Dahmer told Wendy Petricus about the crimes he committed was not allowed to be disclosed to anyone outside the firm. And that's because he gave Ms. Petricus that information so she and everyone else at her firm working on the case could do the best job they could to represent him in court. It should be noted that, unlike the right of publicity, the attorney-client privilege is probably one of the strongest legal arguments that actually could overcome the First Amendment argument. Courts take the privilege very, very seriously, and it's because there's a very strong policy reason behind the privilege, which is that we need to encourage clients to give every detail that is potentially relevant to their case over to the attorney, good, bad, or indifferent. An attorney especially wants to hear the bad details so they can figure out how to work with those bad facts when they inevitably come up at some point in the legal representation. And so the law wants to encourage this sense of openness by saying that an attorney cannot disclose those details of those conversations, even when the attorney no longer represents the client, and in very many cases after the client has passed away. Although the rules for professional conduct can vary from state to state, generally speaking, the concept is the same. An attorney can't divulge communications with their client if the disclosure will somehow disadvantage the client, especially legally. However, there are exceptions to this. For one thing, the client can actually waive the right to confidentiality of a particular communication. The attorney can't do that, but the client can. For another, in many jurisdictions where the details given in a confidential conversation are already public knowledge, that can be a reason to allow that to be disclosed to the public as well, because there's no hiding it if everybody basically already knows the details. So let's be real here. Netflix is a very large company with its own dedicated in-house lawyers that undoubtedly review these kinds of matters. So if I had to guess, they are likely to take something like the attorney-client matters into account before getting access to and publishing tapes like these. Of course, that's a little bit of an assumption, but one that I feel relatively comfortable with making. In other words, it's highly likely to me that either Jeffrey Dahmer actually waived his confidentiality to those tapes at some point before he passed, or it was determined that he was no longer going to be disadvantaged legally by their disclosure. And all of that is to say that I personally don't see Lionel Dahmer as having any real legal recourse here against Netflix. Which leaves another question. For what purpose would he be thinking of suing? What do you think? Let us know in the comments down below. Otherwise, I hope you found this interesting or at least informative, and if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you haven't done so already, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. See you in the next video.